You know what that music means? That means it is time for the show. Good evening, everybody. Happy Wednesday. Welcome to the Joy Reid Show. Big up to everybody that's listening and watching on YouTube. I'm seeing y'all in the chat. Hello to everybody that's in the chat, the Team TJRS members. A new member, 72DAN girl. Welcome to Team TJRS. Hello to everybody in the chat. Big up to also everybody that's on the stacks. That would be Substack and also Spotify. And hello to those who are also catching the show on Spotify. We love everybody. By the way, we've officially crossed the 330,000 subscriber mark. We did that today. So thank you very much to everybody who has subscribed and shared. We appreciate you guys. We are growing by leaps and bounds. September was a really, really great month for the Joy Reid Show. So let's jump into it. There's a lot going on. We have a lot of amazing guests today. I'm really excited about our guest lineup. But let's go back. Let's take you back into time. To 1965, when President Lyndon Baines Johnson signed the Voting Rights Act into law. That was August 6th of 1965. It was affirmation of a pretty simple principle that he also articulated himself, and that you can see him there with all of the members of those dignitaries who showed up, including Dr. King, who was in that room with him, a very multicultural, multiracial group of people who showed up because this was the work that they had done, and they were essentially gaining the benefit of the work that they had done. And he affirmed that. And he also affirmed it in a speech that he gave before a joint session of Congress in which he laid out a pretty simple principle about what we ought to do in this country. And here it is.
It is wrong, deadly wrong, to deny any of your fellow Americans the right to vote in this country.
That's pretty clear. One would think that that's pretty straightforward. Well, that has not always been, let's just say, affirmed in this country. There's John Lewis, that classic iconic photo from the Edmund Pettus Bridge when he literally got beaten, his head almost cracked open by sheriffs because he was affirming the right to march from Selma, Alabama to the capital, Montgomery, Alabama, to march for a Voting Rights Act. And I will note that the reason they had to do that is that the Civil Rights Act of 1964, a year earlier, had left out voting rights because they couldn't get it past a then Democratic Dixiecrat filibuster. The Southern conservatives at that time were the Southern Democrats, the Dixiecrats, and they were filibustering. They finally got the Civil Rights Act of 64, which is equality and accommodations, through, but they couldn't get a Voting Rights Act through. So they were marching again to get voting rights enshrined in the United States Constitution, affirming the 13th, 14th, and 15th Amendments with a piece of activating legislation. Well, we apparently are right back in this place again, having to fight for the very thing that John Lewis bled for on the Edmund Pettus Bridge. I want to refer you to a 2015 piece. Well, actually, let me start with this. The Supreme Court today is taking up a case called Louisiana versus Calais. And it's a case about whether or not we are going to have representation in this country in terms of people being able to have the right to vote. And that case hinges on whether or not the state of Louisiana can use redistricting to make it difficult for people of color, namely African Americans, to vote. Let me read a little bit of this Associated Press story. A Republican attack on a core provision of the Voting Rights Act that is designed to protect racial minorities comes to the U.S. Supreme Court this week, more than a decade after the justices knocked out another pillar of the 60-year-old law. In arguments Wednesday, lawyers for Louisiana and the Trump administration will try to persuade the justices to wipe away the state's second majority Black congressional district and make it much harder, if not impossible, to take account of race in redistricting. Race-based redistricting is fundamentally contrary to the Constitution, Louisiana Attorney General Elizabeth Murrill wrote in the state Supreme Court filing. A mid-decade battle over constitutional redistricting already is playing out across the nation under President Donald Trump, urging Texas and other Republican-controlled states to redraw their lines to make it easier for the GOP to hold its narrow majority in the House of Representatives. A ruling for Louisiana could intensify that effort and spill over to state legislative and local districts. The conservative-dominated court, which just 2 years ago ended affirmative action in college admissions, could be receptive. At the center of this legal fight is Chief Justice John Roberts, who has long held the landmark civil rights law. It has long held the landmark civil rights law in his sights from his time as a young lawyer in the Reagan-era Justice Department to his current job. And it is at that point that I want to refer you guys to a 2015 article that was written in Politico magazine. And for Jason, this is A8. That's where we're going to pull up A8. And this is this Politico piece from back in 2015. There it is. And the title of it is Inside John Roberts, basically fight against the Voting Rights Act. So he's long held, effectively, ever since he was a young lawyer in the Reagan administration, that the Voting Rights Act is unfair. And I'll read a little bit of this story. I may not have it on screen, but I'm just going to read it. John Glover Roberts, a 25-year-old graduate of Harvard Law School, arrived in Washington in early 1980. Harvard law professor Morton Horowitz described Roberts as a conservative looking for a conservative ideology in American history, and he found that ideology in the nation's capital. First as a clerk for the Supreme Court Justice William Rehnquist, and then as an influential aide in Ronald Reagan's Justice Department. At the time, Rehnquist and the Reagan administration were at the vanguard of a new conservative counter-revolution in the law, a legal backlash against the historic and liberal-leaning civil rights laws of the 1960s. Just months before Roberts came to Washington, the Supreme Court had significantly limited the scope of the Voting Rights Act of 1965. As a young lawyer, Roberts eagerly took up the conservative cause, becoming a key foot soldier in the effort to preserve that decision and weaken the VRA. It was a fight Roberts would continue decades later when he replaced Rehnquist as Chief Justice and authored the majority opinion in a landmark case gutting the VRA in 2013. 50 years after the passage of the landmark civil rights law and 35 years after he first worked so hard to dismantle it, Roberts remains at the center of an impassioned debate about voting rights in America, one that shows no signs of ending anytime soon. Bottom line being, John Roberts has never been in favor of the Voting Rights Act. He thinks it's unfair to the South to continue to adjudicate whether or not they should have to get permission from the Justice Department and pre-clear. That's what it's called, pre-clearance. This is Section 5 of the Voting Rights Act. And he thinks forcing formerly restrictive states where they used to restrict the rights of Black people to vote, which is why John Lewis had to march over the Edmund Pettus Bridge. He says states that used to do that should not still suffer in the modern era from having to get permission to change their voting rules. He thinks that's unfair to the South. He thinks the country's history of racism is over, and therefore there shouldn't even be any of that kind of thing. So this case, Louisiana versus Calais, has come before the court under his leadership, the man who doesn't like the Voting Rights Act. Every so often, he's in some ways allowed the Voting Rights Act to remain, but he largely opposes it. Let me play for you, and this is A11 for Jason Reid. This is a piece of the argument today in the Supreme Court, and this is Janai Nelson of the LDF, which is used to be called the NAACP Legal Defense Fund. It's now just called the Legal Defense Fund, LDF. Here is her argument in favor of maintaining a full-strength VRA.
Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court's cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So, for example, This case has affirmed Title VII. It has affirmed Section 1982, the Family Medical Leave Act, and also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because,
Can I ask?
is that,
I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question, that if it's going above and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming
Assuming that
premise
it
of my
does.
question is
Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting the 1982
Nelson, I
amendments.
guess I wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question. To understand, I think, that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist, and those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances, and then the court says, yep, they exist in this situation under Section 2, and so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to figure out what that remedy will be, and maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
And so that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less and less as we see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean, it's a pretty significant showing to establish that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting test. It is data obsessive. It brings in experts and many other forms of evidence to establish a racial violation. There are many cases where the plaintiffs fail in bringing the Jingles 1 precondition or Jingles 2 or Jingles 3 before they even get to the totality of
So if we're talking about a
circumstances.
time limit, you would say maybe it's with respect to the remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just,
No.
yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that prohibition of race discrimination on voting and does not require a time limit.
Thank you.
With the time I have remaining, I'd like to mention that there are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence of it, or the declining ability to show a Section 2 case, is because of the success of Section 2 over the past 4 decades. And we would be reckless if we determine that Section 2 somehow is no longer needed simply because it has been so successful in rooting out racial discrimination in voting. There's also, as I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Calais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use.
And joining me now is the brilliant person that you just heard and saw, and love that headshot too, fabulous. The person who was just making that argument before the United States Supreme Court, Janai Nelson, who is, I want to make sure I read her title correctly, President and Director Counsel of the NAACP Legal Defense Fund. We just call it LDF now. Janai Nelson, thank you so much for being here. Congratulations on your first Supreme Court oral argument. I played a big chunk of it and you were back there listening to it as I'm texting. You're like, don't make me listen to it. But you were so brilliant. I have to just, first of all, just congratulate you and ask how it felt to make this argument, particularly such a momentous case.
Joy, it was truly an honor. I wish we weren't there. I wish we didn't have to make this argument. Frankly, we shouldn't have to make the argument, but I was honored to be able to carry forward the mantle of so many of my predecessors who have done the same thing in challenging this court and forcing this country to be its best self. So it's part of the job.
It's part of the job. And unfortunately, as you said, I wanted to start with the fact of LBJ. We just celebrated, I feel like 10 seconds ago, the 60th anniversary of the signing of the Voting Rights Act. And apparently, according to some of the conservatives on the court, just my reading of it and listening to some of their arguments, they feel like that's enough. 60 years of freedom, that's enough for the blacks. And it is now time for the blacks to step aside and allow Republicans in the South to draw whatever districts they like. And if blacks get no representation, so be it. What did you make of the arguments on the other side, or the quality of the arguments? And do you feel that your arguments resonated with the 6 that need to be turned? Well, let's say not say 6, because 2 of them are unturnable, but the other ones.
Well, I hope we get a 9-0 vote in our favor. I think the law compels that, but we only need 5, and we'll take whatever we get to preserve the Voting Rights Act. I will say that, you mentioned LBJ. LBJ, when he signed the Voting Rights Act, said that it was one of the greatest achievements in the history of American freedom. And he didn't talk about it in terms of just Black people. He didn't talk about it in terms of party and politics, which is what, many members of the court and some of my opponents tried to do. This was really about American freedom. It's about ensuring that we have a robust democracy that makes us an enhanced, secure country and fulfills our constitutional obligations. So I really wish that we all saw it that way. And unfortunately, the state of Louisiana, the lawyer for the plaintiffs, and also the United States that was represented today, the Department of Justice was there as well, didn't seem to share that belief, and that obviously is disappointing. Their arguments went in many different directions, some of it quite contradictory, some of it very irreconcilable with current law. I hope that the justices understood and saw that, and I hope that they remain faithful to their own law and their own words.
Let me play a couple of clips for those who didn't watch the oral arguments. They were 10 a.m. this morning. So this sister has had a long day. she's been working. It's been a long day. So I appreciate you taking the time. Let me play, Jason. This is 8:13. This is an argument in which Justice Ketanji Brown Jackson, Justice Jackson, is receiving an argument from the lawyers for the state of Louisiana. So this is 8:13. Whenever it's ready, Jason.
I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's not,
black district.
because again, just trust me on this, the second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
The other side, and I will note that it seemed that they picked lawyers of color. They picked non-white lawyers. That's what it seemed like to me. You don't have to comment on that. I'm just gonna say that it looked to me like they were trying to get people who were not white on the other side to argue. I'm just saying that. But when what do you make of that argument? What they're saying is that it almost sounds like they're saying that black people don't deserve a second seat in the Louisiana congressional delegation because somehow it's that they're getting it unfair. They almost sound like they're making like an anti-DEI argument about the seat. Is that how you read it?
It is, yes, how they're trying to frame it. It actually ignores the whole impetus for Section 2 even being brought into the picture, and that is a record of substantial discrimination on the part of Louisiana. It's as if we just came forward and said, hey, we want a second district for no reason at all. No, we want a second district for Black people in Louisiana because they are numerous enough, they are geographically compact enough, they have suffered external discrimination, and the state of Louisiana was very, very particular in what it said about its goals for drawing maps. And every time we met their goals, every single time we submitted a map that they said is what they wanted, if it had another Black district, they said no. And so it was clearly a way to minimize and cancel out the growing political power of Black people in Louisiana. And this is happening at the same time that the white population is declining. The white electorate in the original map controlled 83% of the congressional districts, even though they only comprise 58% of the electorate. I mean, if you're talking about an imbalance, if you're talking about unfairness, if you're talking about superproportionality in favor of a single group, that is it, and it's in favor of white people. Even now, in the map that we are defending, they control 66% of the congressional districts, and they are only 58% of the population. Now, numbers alone are not going to win a Section 2 claim, but they are an entry point. They do tell you that something might be wrong in the system if things are that imbalanced. And unfortunately, the state of Louisiana wants to get out of the obligation of complying with federal law. And sadly, we know that the only way that we've been able to get, a change in the complexion of elected officials across the country is by virtue of all the work that's been put in for the past 60 years through the Voting Rights Act.
Yeah, I mean, and look, this is my bad that I didn't prepare this so that Jason can have it. I don't know if you guys can even see this. I'm going to turn my laptop around and see if you guys can see this map. This is the New York Times. They have put together what it would look like. The map that you see that's got some blue on it, that is the current maps. If this were to happen, this is in theory what Republicans could do. Can you all see that in the chat? Let me know if you guys can see it. I don't know if my team TJRS and my readers can actually see it, but the reality is the South, which is where more than half of African Americans live, you would essentially allow Republicans to eliminate not some, but all of the potentially Black majority districts in Tennessee, Mississippi, Alabama, Louisiana. You would leave South Carolina. These states would have no Black representation in Congress, none. And this is where half of Black people live. So it would go from 24 seats across these states, in states where they generally only allow Black folks, who in some cases are a third of the population, to only get one seat. Mississippi has all those Black people. They only have one congressional seat that has a Black person in it. They managed to get 2 in Alabama by going to court. They've managed to get 2 in Louisiana by going to court under the Voting Rights Act. You're talking about some states where there are a third Black and have not one Black congressperson. That's the outcome that Republicans want, right?
Yeah, and so let me say, we don't look at it in terms of party. We're looking at it just in terms of the ability of Black voters to exercise their power for whomever they choose. And I love that you brought up the issue of Mississippi and then also Arkansas. Those are 2 states with a substantial Black population. The state of Mississippi has the highest percentage of Black people of all states in the entire country. And as you said, they only have one congressional district where Black people can actually choose their representative. That is because it is so difficult to bring a Section 2 case and win that we have been unable to succeed in doing so in Mississippi. So the idea that somehow Section 2 is running amok and we're just able to get districts popping up all over the country that are unfair to white people is so patently false. Section 2 is already significantly constrained and only produces a result in favor of Black voters when you have a substantial showing of discrimination, as we have in Louisiana. And even on the partisan issue, which of course, my opponents really wanted to make this a partisan issue because I think they thought that would be appealing to the court. And also the law is much more favorable when it comes to partisan issues. But we have 13 districts that have been produced from the Voting Rights Act that have elected Republicans. Because again, we are more concerned about giving Black people their volition, their ability to determine for themselves who represents them, and to ensure that they have equal footing in the electoral process, whether that's in support of Republicans or Democrats. And just because Black people happen to be more aligned with Democrats does not mean that they can be punished in our political process, doesn't mean that they can have their right to vote denied. So that can never be a basis. There's a constitutional right to be free from race discrimination in our Constitution. There is no equivalent right that has anything to do with party, that has anything to do with partisanship, and that cannot be the excuse for discriminating against Black voters.
Right, and because the reality is, politics in the country is so racialized that both parties have been subject to white flight. Just as when a Black person moves into a majority white neighborhood or an all-white neighborhood, lots and lots of white people physically move, sell their houses, and leave. When Black people who were almost entirely Republicans moved into the Democratic Party, the whole South were Democrats. The whole South were solidly conservative, right-wing Democrats. And Black folks and liberal white people were Republicans for like 100 or more years. And then in the 20th century, when the flip happened, during FDR, a little bit during Woodrow Wilson, when Black people moved from the Republican Party and began moving into the Democratic Party because it was the only way to get power in the South, they said, well, this is where the power is. We're going to try to come in there. White people skedaddled and went in the Republican Party. That is why the party switched. Understand, it was just white flight. And so this isn't about partisanship, because wherever the majority of Black people are politically, the majority of white people leave and go to the other. These parties could switch again. If Black people substantially became Republicans, you'd have a lot of conservative white people go back to being Democrats, because it is more race than anything else. Do you feel that the 6 conservatives, and I really actually don't even mean all 6 of them, because some of them I think are bought and sold, but John Roberts is kind of the key, because he is an anti-voting rights figure for a long time, but also wants the esteem of the court to remain. What were his sort of key questions that kind of told you where he's standing?
Well, I think John Roberts occupies a very, very interesting position here. He is the author for the majority of the court in a case called Allen versus Milligan, which is the case that we won 2 years ago out of Alabama that created that second Black majority district. And that opinion is a fierce one. It is very strong in embracing long-held principles around the Voting Rights Act. The Chief Justice wrote for a majority and quashed many of the very same arguments that the state of Louisiana tried to put forth today, and that came up. And I'm hopeful that the 5 individuals who were part of the majority in Milligan will continue to hold their ground and hold the course. You know, what's interesting is one of the questions that has come up is about whether Section 2 should have a time limit. You know, whether because it has, you know, a remedy that at times can use race, it somehow must be limited. But the point that you just made about history and the cycles show you that you need an ever-present check on discrimination in the process that's not about party, that's about making sure race is not used to manipulate outcomes, because people can switch parties. The political winds can go in any different direction. But what is permanent, what is enshrined in our Constitution, is the right to be free from racial discrimination in voting. And we need a statute that ensures that that is nonpartisan, and that's what we're defending.
Janai Nelson, a brilliant mind, a stalwart defender of civil rights and voting rights. We appreciate you. Congratulations on making a successful, I think, brilliant, really well-crafted argument before the United States Supreme Court. If you all do not prevail, it will not be for lack of brilliance and trying and just true integrity. And I just want to congratulate you for all of those things. Thank you, my friend. I appreciate you being here.
Thank you, Joy.
Thank you very much. Well, there you have it. Janai Nelson, who made her first argument. This is her first time. She's done a lot of arguments before the Supreme Court, but she was the lead attorney on the other side of this Louisiana versus Calais case. So kudos to her for doing that. Thank y'all for tuning in. Be sure to like and subscribe. Share this channel. Make sure that everybody subscribes to the YouTube channel. 70% of people are lurking, watching these shows and not subscribing. Why would you do that? So make sure that you like, subscribe, and throw some comments in. Thank you all for joining the Joy Reid Show. See you on the next one, and goodbye for now.